Tantor Audio, a division of Recorded Books, presents Bizarro, the Surreal Saga of America's secret war on synthetic drugs and the Florida Kingpins it captured, by Jordan S. Rubin, narrated by Stephen Bowlby. Intro. Bizarro. Burton Ritchie called the cops on himself. It was the summer of 2012, and the Drug Enforcement Administration just launched Operation Logjam, the first nationwide synthetic drug takedown. Among the agency's targets was a Las Vegas warehouse that pumped out kilos of spice. The drug, misleadingly known as synthetic marijuana or fake weed, was sold in colorful gram-quantity packets at head shops and over the Internet. Spice was more potent than the natural plant and, oddly enough, legal. Or so it seemed. The feds would later call ZenSense, the Florida-based company that ran the warehouse, one of the world's largest spice operations. Burton owned ZenSense. His 20% partner was Ben Galecki. The men crossed paths at Narcotics Anonymous, of all places, when they were teenagers in the early 1990s. The industry they found themselves in decades later was shifty. Merchants marketed spice as incense and potpourri, but no one bought the stuff to create a relaxing scent in the living room. Products were labeled not for human consumption, but everyone consumed them. Whatever the morality of the venture, a lucrative one to be sure, Burton and Ben were convinced the chemicals inside of their spice, called synthetic cannabinoids, were legal. They paid for lab tests to check for controlled substances. They quarantined chemical shipments imported from China before getting the green light to distribute to shops around the country. They registered as an LLC and paid taxes. After the DEA raided his warehouse, Burton called a cop he knew in Pensacola, Florida, where they were headquartered. The cop put him in touch with DEA Special Agent Claude Cozy. Burton explained to Cozy over the phone that night why he thought the feds were mistaken given the company's compliance measures. He invited the agent to visit their Pensacola facility and see for himself. Cozy accepted the invitation, telling Burton he'd come the next morning and not to worry in the meantime. "Don't lose a minute's sleep over this," the DEA agent told the man whose drug warehouse was raided that day. "If you had anything to worry about, we wouldn't be talking over the phone." They met the next morning. Burton gave Cozy a tour. He handed the agent packets of ZenSense spice, a vibrant array of catchy brand names like Bizarro, with its Superman-themed purple and yellow label marked with a backwards S. Burton told Cozy he'd shut down the business if the agent told him to. Cozy didn't. The lawman said it looked like Burton was trying to comply with the law. Burton and Ben moved on with their lives, embarking on successful careers in film and entertainment. So, how did they land in federal prison, convicted as drug kingpins, after being indicted years later in 3 states and taken to trial 3 times? The answer lies in the weirdest chapter of the war on drugs, a synthetic saga that's unfolding to this day. It stems from a little-known Reagan-era law called the Analogue Act. The 1986 law banned substances that are substantially similar to controlled ones. But what does substantially similar mean? The amorphous test has left people guessing about what's legal. Unlike the traditional war against heroin, cocaine, and other well-known drugs, when it comes to new substances, the government doesn't always announce which ones it thinks are illegal before bringing charges. Adding to the uncertainty, the DEA's own scientists have disagreed about which chemicals are substantially similar to others. Indeed, a senior research chemist with the agency thought the spice Burton and Ben sold was legal. That would have seemed to save them. But the government chemist was arrested before he could take the stand in their defense. 1. Humpty Dumpty's Designer Drug War. In the spring of 1990, Charles Burton Ritchie sold a foil-wrapped sugar cube to an undercover cop at a Pensacola nightclub. The state prosecutor's office brought LSD charges against the 19-year-old addict. The judge set bail at $10,000. That was more than Burton, he goes by his middle name, could afford on his mall store salary from Cutlery World. His mom, Linda, refused to bail him out. She thought her son was on the wrong path. He'd been drinking whatever liquor and taking whatever drugs he could get his hands on. Though he was charged with pushing acid, there was nothing revolutionary or spiritual about Burton's offense. That March night at the Place on East Indentencia Street, Burton was turning a profit, however meager. The Alabama-born hustler had what one friend called a selling ice to Eskimos persuasiveness, what another called the ability to sell shit-covered popsicles to women in white gloves. The cube was just another widget for Burton, no different from the cinnamon toothpicks and lollipops he sold growing up. Burton's mom worked with his public defender to put him in a pretrial diversion program. The judge gave him probation, accepting a no-contest plea to the drug charge, it appearing to the satisfaction of the court that you are not likely again to engage in a criminal course of conduct. The judge's boilerplate order read, "The ends of justice and the welfare of society do not require that you should presently be adjudged guilty and suffer the penalty authorized by law." The deal came with a laundry list of conditions, like drug testing, counseling, and paying various court fees. The arrangement kept Burton clean. He hasn't used since he drank a celebratory beer after his release that summer. It also kept him out of prison, for a couple of decades. Meanwhile, another young entrepreneur faced drug charges out west in Colorado. The defendant there beat the case too, but only after a strange court battle, foreshadowing one that Burton would fight years later. Damon Forbes was a biochemistry student at the University of Colorado. He ran what the feds branded a phony company, Isotech Labs. Its address was his mom's house in Denver. Through his company, Forbes ordered a substance called AET. It was previously sold as an antidepressant under the brand name Monets, before the Psychic Energizer was taken off the shelves in 1962, following reports of negative side effects. But AET still wasn't controlled. It was available directly from chemical companies. Writing on Isotech Labs' letterhead in 1989, Forbes ordered AET for laboratory use only, not for drug, household, or other uses. Undercover agents bought thousands of dollars worth of AET from Forbes and his associates. The sellers supposedly said it was ecstasy, but lab tests showed it was AET, not the controlled substance MDMA that's synonymous with the euphoric drug. But without a law in the books saying AET was illegal, what could the government do? As it turns out, there was a law in the books saying AET, and possibly anything else, might be illegal. The Analogue Act. It punishes people who sell drugs that are substantially similar to controlled ones. But the DEA chemist who examined the AET in Forbes' case didn't think it was substantially similar to a controlled drug. That meant it wasn't an analog in the government chemist's view. In other words, he thought it was legal. Nonetheless, the DEA brought the case to the Colorado U.S. Attorney's Office. But after he heard about that DEA chemist's opinion, Assistant U.S. Attorney and future U.S. Congressman Ken Buck declined to prosecute in 1990. That would have seemed to settle the matter in Forbes's favor. The government forged ahead. In 1992, the same U.S. Attorney's Office charged Forbes and others, including his mom, under the Analogue Act. Different prosecutors and a different DEA chemist backed the effort. Seizing on that internal conflict, Forbes moved to dismiss the case. He argued that the Analogue Act was unconstitutional, at least when it came to AET. He said the law failed to give clear notice of what's illegal. A citizen cannot determine whether AET is a controlled substance analog, his motion read. Apparently, the government determines the issue depending upon which expert it consults. The government's chosen DEA expert against Forbes, Frank Sapienza, helped write the Analogue Act. He defended the law and its application to AET. Unlike the first DEA chemist, he thought it qualified as an analog. The judge overseeing the case, Louis Babcock, was appointed to the bench by Ronald Reagan, who signed the Analogue Act into law. Judge Babcock held a hearing on the novel issue in November 1992. Forbes subpoenaed Roger Ely, the DEA chemist who thought AET wasn't an analog. Testifying at the hearing, Ely explained the difficulty he faced in trying to conduct the substantial similarity analysis. "There is no guideline," the chemist said, when pressed by the prosecutor on cross-examination. "There certainly isn't a definition of what is substantially similar in the chemistry text that I have looked in, so there's really no guidance as to how to draw that kind of a conclusion." On cross-examination by the defense, the government's expert, Sapienza, said, "Part of the problem here was that we have different people using different methodologies." Judge Babcock dismissed the case. "I, without any doubt, conclude that the statute here, under the circumstances, applies no fair warning of the prescribed conduct," the judge said. "Not only is there a lack of scientific consensus on this question between the government and defense," he said, "there's a lack of scientific consensus on this very question intragovernmentally." The judge further took the government to task in his later published opinion. "Perhaps more importantly in this case," he wrote, "the analog definition as applied to AET is so vague as to permit arbitrary enforcement." Noting that the first prosecutor, Buck, rejected the case in 1990, Judge Babcock observed, "Now, in 1992, Forbes is prosecuted by the same office for the same alleged offense. Nothing changed in the intervening 2 years, except the personalities of the government prosecutors and their hand-picked DEA chemists." The judge wrote that the case illustrates precisely the evils attending the delegation of basic policy decisions for ad hoc, subjective resolution by those who wield prosecutorial power. The Reagan appointee's rebuke sounded like it could have come from a fierce drug war critic. In fact, some of his language wasn't far off from the words of a counterculture chemist known as the godfather of ecstasy. Alexander Sasha Shulgin had a straight-laced resume in some respects. The renowned biochemistry Ph.D. had been a top researcher for Dow Chemical and enjoyed a working relationship with the DEA. But he became best known for popularizing MDMA and for cataloging his synthesis and use of psychoactive compounds. With his wife Anne, he authored 2 classic books at the intersection of science, psychic exploration, and drug war criticism. The first, published in 1991, was P-Cal, short for Phenethylamines I Have Known and Loved. Phenethylamines include the MDMA, whose prevalence Shulgin was credited with, or blamed for. The sequel, in 1997, was T-Cal. It dealt with tryptamines, which include the AET from Forbes' case and the LSD that landed Burton Ritchie in a Florida county jail. But the DEA saw Shulgin's genre-defying works as something simpler, cookbooks on how to make illegal drugs. Agents raided Shulgin's home lab in California after he published P-Cal, which led him to losing his DEA license to research banned drugs. Shulgin was an early critic of the Analogue Act. In a 1987 lecture, he called the recently passed statute one of the most freedom-restricting things that has ever been put into the law. He wondered, is the structure of a 1986 Pontiac's taillight substantially similar to a 1984 Chevrolet's? Well, he said, in some ways yes, and some ways no. Years before the Forbes case showed that the DEA couldn't agree with itself on the issue, Shulgin told students, "You're going to have a conflict of expert testimony. They're totally different. They're substantially the same." The chemist continued to pick the law apart in a 1990 letter to the Journal of Forensic Sciences, which became a defense exhibit in the Forbes case. Shulgin began with a quote from the upside-down world of Alice in Wonderland, and Lewis Carroll's Through the Looking-Glass. "When I use a word," Humpty Dumpty said in a rather scornful tone, "it means just what I choose it to mean, neither more nor less." "The question is," said Alice, "whether you can make words mean so many different things." "The question is," said Humpty Dumpty, "which is to be master. That's all." The term substantially similar, Shulgin argued in his letter, is hopelessly vague. He alleged it was crafted with this very goal in mind. By designing the net, which has a completely variable mesh size, one can catch whatever fish one wishes to, and let escape another fish that is not wanted. Shulgin foresaw problems with the law that would plague defendants, prosecutors, judges, and juries for decades to come. There is no objective standard to the term similar, and certainly none for the phrase substantially similar, he wrote. There is no right answer. There can never be one. And yet, charges are being brought and convictions are being obtained based on the scientific opinions presented in criminal cases. Eventually, Shulgin predicted, a challenge to this preposterous wording will be made that will result in its removal from the law statutes. But until then, I fear that it will be imposed by the law enforcement groups when desirable and ignored at other times. Any law that allows selective enforcement, he wrote, is a bad law. But how did this bad, vague view, as Shulgin put it, come to pass? The rules of the drug game were too clear. 2. Frozen addicts, emergency powers. Doctors were stumped. A series of patients, all heroin users, could barely move or speak. It looked like they had Parkinson's, but they seemed too young for the debilitating disease. It turned out the frozen addicts, as they'd be called, were crippled by a synthetic batch gone wrong in early 1980s California. The problem stemmed from the amateur synthesis of MPPP, an opioid that mimicked the controlled painkiller Demerol. Clumsy MPPP production created a byproduct called MPTP, which, doctors learned, is what made the patients freeze. The bad drug batch led to groundbreaking research. Scientists could give MPTP to primates who'd freeze like the addicts did to study the disease. It was ironic that designer drug dealing started a research revolution, the doctor who treated the patients recalled in his book on the ordeal. But as far as law enforcement and politicians in the tough-on-crime 80s were concerned, it was the latest sign that the good guys were a step behind the bad guys. The frozen addicts incident was deemed the first designer drug disaster, but it was just one piece of the puzzle, as authorities battled a seemingly endless stream of drugs simulating fentanyl and other controlled substances. Gary Henderson, the University of California pharmacologist who coined the designer drug term, told the Chicago Tribune in 1985 that the answer lies in understanding users, not drugs. "You can play with the structures endlessly," Henderson told the paper. "Once you know the chemistry, there are almost an unlimited number of chemicals out there that could be made and used and abused. Passing laws is not the answer," he said. "We could spend the rest of our lives compiling lists of illegal chemicals." The government, meanwhile, grew frustrated with the process for listing which chemicals were illegal. The 1970 Controlled Substances Act, signed into law by drug war declarant Richard Nixon, laid out schedules specifying which drugs were banned. But that specificity created a loophole in law enforcement's view, one that underground chemists and dealers exploited by tweaking their recipes as drugs were scheduled. It took months or more to list a new drug under the 1970 Act, which required a multi-factor analysis and review by health officials. The Act also made the government give notice of its scheduling moves, plus the public could weigh in and raise legal challenges. To speed up that timeline, Congress created emergency temporary drug scheduling power in 1984. The feds could now bypass some of the bureaucracy so long as the Attorney General found such emergency action was necessary to avoid an imminent hazard to the public safety. The emergency scheduling provision was just one part of the Comprehensive Crime Control Act of 1984, a massive bill that passed on a bipartisan basis. Ronald Reagan signed it. As a Justice Department lawyer put it in 1985, the statute contains the most significant changes in the federal criminal justice system ever enacted at one time. It ran the gamut of punitive measures, like eliminating parole, broadening asset forfeiture, and increasing penalties for marijuana and other drugs. The DEA appreciated the sped-up scheduling power. The agency used it to outlaw MPPP, whose mutation caused the frozen addicts, MDMA, over objection that scheduling threatened research and therapeutic use, and several fentanyl analogs. But it wasn't enough. While the agency could act more quickly, it was still reacting, drug by drug, and officials had to abide some semblance of regulatory compliance, especially if they wanted to make any temporary bans permanent. The government wanted a better weapon in its arsenal. Attorney General Edwin Meese III warned of new drug dangers in a 1985 speech to the San Diego Kiwanis Club. He informed the civic group that designer drug use rose in 1984 and would likely continue to do so in 1985. That was the bad news. The good news, Meese told the crowd, marijuana use was down. That summer of 1985, the Justice Department sent lawmakers a letter. It outlined the designer drug problem in DOJ's view and provided the language to solve it. The solution was novel, outlawing drugs that hadn't been identified or even created yet. DOJ's letter defined a designer drug as one that had either a chemical structure or intended effect that was substantially similar to a controlled substance in Schedules 1 or 2. Under the 1970 Controlled Substances Act, Schedules 1 and 2 house the most dangerous drugs, according to the government. The letter didn't explain how the department arrived at the term substantially similar, but the phrase existed elsewhere in law, at least in the civil realm, like in copyright litigation. At any rate, the latter argue that even the 1984 law left open a menacing loophole, because activity is not proscribed until the substance in question is controlled through the emergency scheduling process. That is, a drug wasn't illegal until it was illegal. Politicians of both parties were eager to help close that perceived loophole. For once, we may be in a position to launch a preemptive strike and to avoid the difficulties of having to play catch-up. Senate Judiciary Committee Chair Strom Thurmond, Republican of South Carolina, said at a 1985 hearing. The committee's ranking Democrat, Joseph R. Biden of Delaware, agreed. He said the designer drug bill addressed a new and expanding law enforcement and drug abuse problem that could become the drug abuse problem of the 1980s and 1990s. 3. Dr. Frankenstein's. The Justice Department sent one of its top lawyers, Stephen Trott, to testify in support of the designer drug bill. The Washington Post called Trott a true believer who doesn't much worry about what the American Civil Liberties Union might think of his approach. On his way to becoming DOJ's third-ranking official and then a federal judge appointed by Reagan, the career prosecutor blamed many of the country's problems on a permissive attitude toward drugs in the 1960s and 70s. Long before making a name for himself as a law enforcer, Trott was a member of the Highwaymen, a collegiate folk group that topped the charts in the 1960s with a cover of the African-American spiritual Michael Row the Boat to Shore. The New York Times deemed Trott's path an unlikely saga, in which a singer out of the Phil Ochs-Joan Baez era goes on to hold the third highest post in the Edwin Meese Department of Justice. Trott explained the substantial similarity test to senators at a 1985 hearing. He said that he talked to DEA chemists and learned that the test is a scientific exercise that is accepted by the scientific community. He said it simply presents a question of fact that can be adequately coped with in court in any prosecution that ensues. It was important to the government that prosecutors need only prove substantially similar structure or effect, not both. In accompanying written remarks, Trott said that evidence of structural similarity might be hard for jurors to grasp, so the effects option gave them another way to convict. It helped avoid what Trott called a serious loophole. Yet, he expected defendants to challenge the law's constitutionality for being too vague. He sought to pre-rebut such attacks. The law would easily withstand constitutional attack on vagueness grounds, Trott assured lawmakers. The Senate Judiciary Committee also heard from the American Chemical Society, a congressionally chartered group that supported the bill. Sort of. The group liked the idea, but didn't like the DOJ's either-or approach. A representative told senators that legitimate research would be more adequately protected if the or in this definition were changed to and. This change of or to and would emphasize the designing of these substances to produce substantially similar biological effects to those of controlled substances. But that scientific concern missed the point, Trott complained. He told senators that it's extremely time-consuming to gather adequate pharmacological evidence regarding a drug's effect. He said requiring proof of both structure and effect would make charges very difficult to prosecute successfully in court. Asked if the Chemical Society's approach would address vagueness concerns, Trott said no. The vagueness attack would come against the substantial similarity test. Since the substantial similarity standard applies in the proposal to both the chemical structure and effect of the drug, he said, requiring the prosecution to meet both tests would not make the proposal any more precise. DOJ also pressed its case in the House of Representatives, which pushed its own version of the bill. Attorney General Meese wrote to the Appropriations Chair in March 1986 regarding the growing threat posed by the spreading use of synthetic or designer drugs. Meese wrote that the department considered the proposed law a crucial element in the government's efforts to curtail the spread of these dangerous substances. In May, Trott told the House Judiciary Subcommittee on Crime that the feds had backed off the designer terminology. Its allusion to the fashion world, he said, unfortunately trivializes the problem from a law enforcement standpoint, while potentially increasing the attractiveness of these substances from a drug abuse standpoint. He urged the term analog instead. As he did in the Senate, Trott gave examples of why the government needed more power to tackle these analogs and the people making and selling them. He pointed to a clandestine chemist who made analogs of fentanyl, the synthetic opioid that was scheduled. Because the analogs weren't controlled, Trott lamented, the chemist could only be charged with relatively minor offenses, like manufacturing drugs without FDA registration and conspiring to misbrand drugs. When it came to the infamous analog China White, Trott recalled, it took the DEA over a year to get a sample. With the 1984 Emergency Scheduling Act, the government could react more quickly, but it was still reacting. It wanted to be proactive and to put dealers away who tried to skirt law enforcement's conception of the law. Not every congressional witness was sympathetic to the proposal. Harvard psychiatry professor Lester Grinspoon, a marijuana legalization proponent, called the substantial similarity test both vague and unscientific. He criticized the law for imposing criminal penalties without requiring proof that a drug had harmed anyone. Instead, Grinspoon explained, the law relies on the Justice Department officials
Sample complete. Ready to continue?